Welcome to Business Line's State of the Economy podcast, where you'll find insight, analysis, and the story behind the numbers.
Hey there, welcome to the BL State of the Economy podcast. I am Shrivats from Business Line, and today we have a very interesting topic at hand, which is the ongoing legal tussle between the domestic startups and the tech giant Google in the Google Play Store case, or commonly referred as the app billing case. At the heart of the showdown between what many see as a David versus Goliath battle lies the issue of fair competition, revenue sharing, and control over app distribution channels. The controversy in the app billing case, which is now little over 3 years old, revolves around Google's imposition of a mandatory 30% commission on app downloads or in app purchases made through the Google Play Store. Of course, there has been a small climb down of sorts by Google in revising downward the commission, which Google terms it as a service fee, to a maximum of 26%. So, what exactly is this legal spat between domestic startups and Google all about? Which are the legal forums through which the case has moved ever since CCI came up with the historic October 25th, 2022 order on the Google Play Store case? To help us navigate this critical question and do a deep dive into the ongoing legal dispute, we today have an eminent competition law expert in Mr. M. Sharma, who heads the competition law and policy practice in the law firm Vaish Associates since the year 2009. Sharma, who has a wealth of experience spanning over 38 years, holds a postgraduate diploma in economics of competition law from the King's College London. He has worked in the Competition Commission of India as additional registrar during 2006 to 2008 and was responsible for drafting the implementing regulations under the Competition Act 2002. He is a prolific writer on competition issues and has few international publications in noted journals to his credit. Sharma was a pioneer of sorts in having a dedicated blog on competition law. It is called the Antitrust and Competition Law blog, and a very popular one too among the competition law fraternity. Welcome to the BL State of the Economy podcast, Mr. Sharma. So, sir, today we have a very interesting topic which has been a point of discussion at various industry forums across the country is the ongoing legal spat between Google and the domestic startups. So, I would like to ask you first as to how do you see this ongoing epic David versus Goliath battle between the startups and Google?
Very interesting. You put it, I think, in the right perspective, I should say. It is indeed a fight between the big and the small. So, how I see it is that, see, the app developers, the third party app developers, are actually fighting for their right, the right to be fair, to have a fair dealing from Google. In as far as the payment for their purchases made by the consumers on their apps, and even purchases of the apps themselves are regulated by the Google. So they're fighting for a right cause, I believe, and the fight is not confined to India, if I may add. It's a universal fight because it is also going on in it has also gone through its phase in US, UK, and even in South Korea.
Interesting.
So this is a fight which is not confined to India. I just wanted to add this fact. for the benefit of my listeners. And if you want, I can give you the very briefly the this fight which is going on. So in South Korea, it started in August 2021. Google was doing exactly the same thing which Google is doing in India. And the Korean parliament actually dubbed this as the anti-Google law. They made an anti-Google law in South Korea, Telecommunication Business Act, blaming the big app store operations, such as Google and even Apple, from forcing the developers to use their payment system, effectively stopping them from charging commissions on the in-app purchases. So that by law, the South Korean parliament actually stopped it. So it was a regulatory or legislative interference. In the US, similar developments took place in 2022 after the development in South Korea. And in the US, Google was forced to, agree to settlement with the FTC. They actually made settlement with the FTC, and they actually, pursuant to the Google, announced that Google actually allowed the apps to charge consumer directly rather than to have charged them through the Google. So that mandatory payment through Google Pay was stopped in US, and even Google offered to pay 60 million dollars, 630 million to create a settlement fund for consumers, and also paid $70 million into that fund to be used by the states. So this is the story in the US. So in the US, Google is not doing what it is doing in India, and even in the UK. Another interesting thing. So after South Korea, then came the US in 2022, and in UK, as recent as 2023, that is the last year. You see, April 2023, Google has made commitments because the CMA, Consumer and Marketing Authority of UK, started investigating the same allegations against Google. And then Google was given a notice, show cause notice, the notice for, and they had, Google has agreed in April 23, and the commitments made by Google are being examined by UK. So this is a fight which in India has started already, like it has already held, as I said, other jurisdictions.
So, sir, if I may ask, how has it moved on the European Union front?
See, in the European Union, there is no such specific complaint against this payment system. It is in national competition authorities, which I'm not actually aware as of now. I gave you the example of UK, but in European Union, I'm not exactly as of now aware that in which other jurisdictions apart from UK, this same problem has come. It is
As, rega-
actually
as regards the pricing
payment system.
or,
Yeah, yeah.
or the
Google
billing
Pay.
system for apps.
Exactly. We are being, I think this podcast, as I believe, is specific to the extent of the payment system. I'm not
Yeah,
referring to the other issues as of now.
yeah, definitely, sir. We are the issue at hand is only the Google billing case. It's on the
Correct.
app billing case. Yeah,
Yes. So I'm
Uh,
confining my responses to that only.
exactly, sir. Exactly. For the benefit of our listeners, could you help us understand the genesis of this battle in the Indian context?
Sure, I would love to do that. So this Genesis is more or less contemporaneous with the South Korean case in 2021. It actually started in India also in 2020. You see, in India, somebody who was unnamed, an anonymous complainant, XYZ, filed a case against Google on account of using its dominance in the licensable OS market for smartphones, that is Android-based OS, and then forcing the app developers, third-party application developers, to force and the consumer was being forced to use only Google Pay as the payment mode when they were making purchases through the applications on the Google Android store. So Google Play was found to be is the largest, was found to be dominant by the CCI. This complaint started there, and the CCI found that Google's Play billing system, through the Google Play Store, is not only receiving payments for applications, that is for other digital products like audio, video, etc., sold through the Google Play Store, but also certain in-app purchases made by the users for the apps after they have downloaded and purchased the apps from the Play Store. The app developers were also not allowed, to give a direct link to a web page containing an alternative method of payment, say UPI, for example, in India, or use language that encourages the user to purchase digital item outside the app. So it's called anti-steering provisions were used. So the application developers were actually stopped technically by Google from giving an offer to their consumers to make alternate method. They can't even use a language which would suggest that. So if the app developers did not comply with the Google policy of, and this policy was known as Google Play's billing system, GBPS. See, this
Exactly.
Google
Yeah.
Play billing system, GBPS, it was called. It was not permitting the application's users, the ordinary consumers who had Android phone, and the Google had large, mostly the phone users, smartphone using Android phone. There are only two operating software in the world. Either it is Apple's iOS or it is Google, Android phone. So since 95% Google has market share in smartphone operating system, obviously it is akin to a monopoly. Of course, not technically a monopoly, it's a duopoly, but it's like a hugely dominant position Google had. So people had no choice. So the app developers did not, and those app developers did not comply with the Google policy of GBPS, were not permitted to even list their apps on the Play Store. So there was a restriction, put on them. It's a denial of market access in the technical terms, if I can use it. And actually, they would lose out the vast potential of customers on the Android users. So this was the genesis of the problem, and the commission concluded after that assessment the commission made that Google is actually, and there's another interesting fact which I must share with you, that Google was not making this mandatory for its own application, that the YouTube. So Google has its own, hugely popular application, the YouTube app. YouTube in the YouTube purchases made through YouTube, Google was not mandating this GBPS for the common users. This was interesting. So there was not only unfair part, but also discriminatory part. And those purchases which were made, Google was charging something between, you know, 11 to 26%, for the payment made through the red apps, and it can go up to 30%. So up to 30% was charging. So this was the genesis of the problem, and the commission, considered this case, and it concluded that mandatory imposition of GBPS disturbs innovation incentives and ability of both the payment processors as well as the app developers to undertake technical development and innovate, and thus tantamount to limiting technical development. So not only it was found to be unfair, but discriminatory under 42A1 and 2, but also, you know, but also stopping the technical development under 42B2 of the Competition Act. And then also, as I said, denial of market access for payment aggregators as well as app developers under 42C also. So if you are aware of the legal provision, anybody who's listening would understand what I'm saying. So what actually Google was found to be doing was, it was found to be leveraging its dominant position in the market for licensable market OS and App Store for Android OS to protect its position in the downstream market for payments through the app purchases. So that was another angle. 42E was also added. So on all five accounts, you see, of the Section 4 violation, Google was found to have abused the dominance, and the Google was, this policy, this was stopped. The order was of 25th of October 2022.
Which involved nearly 1,000 crore or 900 crore penalty, right?
No, that was a composite order. In fact, there were two orders. One order
Okay.
was the previous 5 days back. The order was issued on the Android smartphone, Android-based order, I can call it, Android
Okay.
Smart OS order, because Google was also imposing mandatory and unfair conditions on the Android OS smartphone makers, smartphone
Mhm.
manufacturers who were using Android as their OS. So that was the main case. This was the second case, and both the cases there was a gap only 5 days. So the
Correct.
previous case of with the order was the 20th October, a penalty
Mm.
of 936 crore was imposed. 1336 crores was imposed, and then in the second order they did not impose any penalty. They only issued the
No, sir.
directions.
If I remember, they imposed a 930 crore penalty.
1337 was imposed on the Android
20th.
OS store,
Yeah.
and I think 936 crore was, yes, you're right. And I
Yeah.
stand corrected. Was
Yeah.
imposed for the payment, the Google payment method. I'm sorry. So
Yeah. Yeah.
936.44 crore was also imposed on
Correct.
this in this particular issue.
Mm.
So against that, Google went and appealed in the NCLAT. And
Mm.
in the NCLAT, it could not get a stay against these directions, of
Mm.
substantive directions of market correction issued by the CCI. But
Mm.
it did one thing. It allowed the user a choice. It allowed a user a choice for only the users, not the app developers, choice for
Mm.
using the alternative methods. But the payment of commission continued. Mandatory payment of commission up to 26% continued, even if when the user uses the so-called user choice billing system. So GBPS got converted to user choice billing, UCB. And in UCB also,
Mm.
you had to pay up to 26%. So it was 11 to 26%. And this was beside the 15% flat percentage fee for any customer, downloading the application, a paid application from the Google Play Store.
So, sir,
So,
in your view, the
hmm,
updated UCB policy, which came into effect on April 26th
26th. Yeah,
last
yeah,
year,
yeah.
uh, did it solve for the contentious issue of denial of market access for payment aggregators as well as app developers?
Yes. So you say your question is very specific.
Yeah.
So as far as the universal, the user choice billing has
Mm.
actually resolved the issue for discrimination for the users of the smartphone, that is the consumers, not for the app developers.
Not for the
So
app developer.
app developers
Mm.
can certainly, because the issue of mandatory payment of commission still remains,
Mm.
but
So
the discrimination has been done away with.
sorry to
This
interrupt. The main growth of the domestic startups is the quantum of commission and not
Yes.
commission per se, right?
No, not only the quantum per se. Quantum, of course, is very huge because the all
Mm.
other development methods, other payment methods charge only 3%, 0 to 3%, and as per the RBI guidelines, also it can't be more than 5%.
Mm.
So because Google is in a dominant position and leveraging its dominance, as I said, is
Mm.
mandating the imposition of such a huge commission, even after
Mm.
you under UCB. So
Mm.
that is the main ground. So the discrimination as far as GBPS is concerned has been removed by Google, but it has not removed the problem of the developers. So that's why the app developers and aggregators are up in arms against Google.
Okay, so their point of view is there should be no case for levy of commission, or their point is the commission rates are high.
Their point is that the commission rates are very high, excessively high.
Okay. Mm.
It's not only they of course they agree that they'll have to pay some commission.
Mm.
They're not saying they will not pay commission, and that's why in the Madras High Court when they went, they
Mm.
specifically refer to the RBI's guidelines, which which regulate the quantum of the commission payable.
So, sir, when you talk of Madras High Court, help our listeners to understand what is this Madras High Court. I mean, chronologically, if we talk, October 25th, the order came from CCI. It found
Yes.
Google to resort to unfair competitive
And in April,
practices.
right, and in April 23, Google removed the discrimination as far as user choice is concerned. Started user choice
Mm.
billing. But
So
then the
why did all the startups go to Madras High Court in June?
Yes, very good question. So I think the answer is this, that the startups were waiting for the CCI because the Google did not get, as I said, any stay order in the appeal which it has filed, which is still pending. Mind you, there were two appeals. The earlier appeal was disposed of by the NCLAT, that appeal in which the Android OS order case, that with the Android OS was the main issue. That appeal was disposed of by the NCLAT, and the Google is in second appeal before the Supreme Court. In that appeal also, the Google's penalty was sustained, you know, but the directions were not changed, and Google was found to be abusing his dominance. But that's beside the point. But the second appeal, which was against the 25th October 22 order, is still pending in NCLT. And in that appeal, since no stay order was granted, as I said, against the substantive directions for removing this discrimination, etc. So what Google did was, Google, though removed only the discrimination for the users, but did not remove the discrimination for the app developers, or did not remove the excessive or unfair so-called commission which was charging from the app developers. So that point still remained. So the app developers actually waited the commission to get that enforced, because there is a section 42, which mandates the commission to enforce its directions. And if somebody does not do it, there is a provision for prosecuting that person. So it went on. And I believe that the app developers also, after waiting for some time, filed an application before the CCI for enforcing its orders. And that also did not happen. Then I think the developers actually lost their patience, I would say, and rightly so to some extent. Then they started looking for alternative remedies. And alternative remedies naturally would not lie in the Competition Act. It will lie under the civil law, the common law, under the Contract Act, because rightly said, the this imposition of a commission which is so high, it amounts to a light of restraint of trade also to some extent under the Contract Act. And of course, beside violating the RBI guidelines, as I just said, under this act is called the PSS Act, and there is a guidelines on regulating of payment aggregators and payments gateways. 2020 is also there. So all those things, I'm sure the app developers have their own association also, and they must have consulted legal experts, and that's why their counsel suggested to them to try out the alternative remedy, before the civil court. And then they went to the High Court of Madras. And in Madras High Court, they took the same view that not only the CCI has, of course, they did mention, they did not hide this fact that they are already before the CCI, and they filed an application under Section 42 for asking the CCI to prosecute Google for non-compliance with its order of 25th of October 2022, and that say was pending. But then they said the CCI, could not regulate the rates of commission. So that is the thing which I would like to, focus on, because commission is not a regulator, it's not a price regulator. It is a competition regulator. It does not have powers to regulate the rate at which, a company will charge its service charges. So basically, it's a contract between the Google. It is an upstream, and the app developers are using that in Play Store at the downstream. So it's a contract. And in this contract, what rate would the Google charge from them is basically between the two parties. It's a privity of contract. So this is an admitted fact that the Competition Commission does not have power to regulate the rates. And it actually, by the way, but I also tell you, it also happened in the case of T Series. T Series, a similar case also arose. T Series was also charging, very high rate from the FM music, which was licensing its copyright of the film and music, Bollywood music. So the same case, when I was a part of that case, incidentally. So that there also the CCI did not dictate the rates, because then our point was, we were representing T Series, and our point was exactly the same as Google would have said, that it's the copyright board which is the empowered under the Copyright Act to decide the rate, the reasonable rate, so called, because they had the power. So the same thing in here also, the Google knew that CCI does not have that power, and the app developers also knew that CCI does not have the power. That's why the answer, according to the app developers, lied before the civil court, and that's why they raised the issue in the High Court. But in the High Court, what happened was, the High Court, there Google was successful, actually speaking, to get the jurisdiction itself ousted. Because in there, it took the help of Section 61 of the Competition Act, which outs the jurisdiction of civil courts in all competition-related issues. So the High Court was convinced by the counsels for Google. There was a long order. I mean, one can go on and on. But the long and short of this is that the High Court found that the commission, since it is already sub judice, the appeal is sub judice before the NCLT, and the Competition Commission has also given an order. So it found that there is no reason for the High Court to interfere, in that matter. And in my blog, if you can see, I've referred to the increasing tribunalization of the judicial system. And in that, there is a judgment of L. Chandra Prakash, very famous judgment of the Supreme Court, when the CAT itself was challenged. The competition, the Central Administrative Tribunal, when it was first made, was challenged in the Supreme Court. A full bench, 7-bench judgment of the Supreme Court said that tribunals have to remain. Tribunals are not ultra vires the Constitution, etc. Because the writ power of the jurisdiction of the High Court remains. But tribunals have their own role because they are expert bodies, created specifically for the purpose for which the Act says. So here in this case, the Competition Commission of India and the Competition Appellate Tribunal, now the NCLT, are expert bodies which are supposed to, adjudicate upon the competition issues. That's why the Madras High Court refused. And I must also add here, this is a trend. This is a trend which is going on in the Indian higher judiciary. High courts after high courts and even the Supreme Court have actually, avoided interfering in the experts' domain, or the competition domain particularly. And I can also refer to the case of the car spare part cases, Madras High Court order, etc., where Madras High Court and even Karnataka High Court, even Bombay High Court, all refused to intervene. Ultimately, the appeals are now being, adjudicated before the NCLT about the car spare part who refuse to open their markets for the secondary market, etc. So the point is that Madras High Court has refused to intervene in this case, and the matter is now in the Supreme Court. So I mean, the matter is sub judice. I don't know which way the Supreme Court will take the view, because Google is also right to the extent that the rate determination is not within the domain of CCI. So who will determine the rate? And reasonableness they can only see. But then the issue is not reasonableness. Here the issue is of unfairness. Here the app developers are saying it is not only unreasonable, but it is unfair and excessive. So these are the issues which are actually contentious issues, which only the time will tell how it will figure out. But as of now, the matter is in the Supreme Court, because the app developers have challenged that division bench High Court order also, which allowed the single bench order, which had dismissed Google's appeal, and so it is before the Supreme Court.
Excellent, sir. So, thank you for the great perspective on that. So, I have one question, which is that Madras High Court had asked startups to go to the CCI, saying that CCI is the right forum to give them any remedy.
Yes.
However, the startups went to Supreme Court in appeal against the Madras Division Bench order. In a way, how do you see this? Do you think? And in fact, when they approached Supreme Court in that petition, they have alleged inaction by the CCI as a reason for moving the Supreme Court. So, do you think they are justified in that?
Yes, no, it's a very good question. See, I will be very careful in answering this question, because though the app developers, as a consumers of justice, if I can use this term, are justified in finding in opening their frustration out, before the courts, because the CCI has, for whatever reason, not enforced its Section 42, which is the only provision which is not appealable, and under this, even a prosecution, even imprisonment is provided. While they are right in doing so, but we have to see the other side's story also. You see, the commission is a quasi-judicial body. It has a process to follow, and in the process, it has to give sufficient time to even Google to respond to the application. And I'm sure this must be the reason why the commission has not done what it ought to have done till now, because the commission must be waiting for the Google's response, and Google might be, and I'm not alleging anything, but Google might be delaying, though I don't, though I do not expect a company as responsible as Google to do that, but it could be the reason. Another reason could be, CCI itself was in limbo, for some time, when the last chairman had retired, and it took some time for the new members to take office. So this intervening period, about 8 to 8 months, the selection of the new chairperson and the CCI members, etc., I think is also responsible to this, for this kind of delay to that extent. But having said that, to avail the right remedies is the fundamental right of every citizen. So the app developers are right in saying what they've said in the Supreme Court, that the CCI is not doing what it has to. And why they say so, I will also add one more sentence here, is because CCI should have, should have actually fastened, should have expedited, because it's a very big issue. It's a very big issue. It's not a case of a single company, being targeted. The entire India's online third party developers are in problem, and the CCI has already held that Google is doing wrong. So why did not CCI actually expedite its process of Section 42, of prosecuting the Google for non-compliance? So to that extent, I mean, I can only give a very, very subjective answer with a caveat that CCI cannot be entirely blamed, but app developers are also right in what they're saying. And I don't think that CCI is entirely to be blamed. I mean, I will be only add this to the extent, but yes, app developers are also right. They have the grouse is very justified.
So do you think this legal battle between the David and the Goliath has, in a way, what does it tell us about CCI's image as a trustworthy, credible, no nonsense, and fair regulator? Has it taken a hit?
Yes, it has taken, no doubt about it. In fact, if you see, I have commented on this in my blog also, which was published, on 12th February. I very much have actually said so what you're saying, that the commission actually has, because of these issues of not enforcing section 42 powers fully and in timely, I would say timely enforcement of its orders actually has brought down its credibility or its trust among the people as a no nonsense and strict fair market regulator. Because the commission has perhaps forgotten that this is the only power which is the statute has given to them, which will actually make the big corporate stand up and understand. Because here even the imprisonment is provided. Up to 3 years imprisonment can be given if they don't comply by this chief metropolitan magistrate. So that it actually has definitely to some extent eroded the credibility of the CCI, which it has built over a period of 10, 12 years, such great efforts by its predecessors. That I'm sorry, I mean, this should not have happened, because after cease and desist order, the universal choice billed which the Google did was not sufficient as far as the complaint before you are concerned. You see, it is not the users who have come to you. The app developers had come to you, and the app developers' problem still remains. Of course, Google has settled to some extent the choice of the users, the actual smartphone users, but then that's not sufficient. You have to address to every stakeholder, and the app developers are the people who are the innovators. They have to be protected by the law. And the Competition Commission is the only body, and the Competition Act is the only law which can protect them, which is as it is seen from the Madras High Court judgment. And in my personal view, I doubt whether the Supreme Court will also interfere in this. So ultimately, the ball will go into this before the CCI's court only. Again, and ultimately, as I said in the car spare part case, the appeal will land up before the NCLT. And in NCLT, what we have? We don't even have a dedicated bench for competition cases. Competition cases are going on for years. I know I've got a number of appeals which have not come for hearing for the last 2 years because they are busy in the insolvency matters. There is a need for a dedicated bench like the competition appellate tribunal used to be earlier. So there are lots of issues with the competition landscape. Srivas, I can go on, but the point is, I do not personally think that the credibility of the CCI is completely eroded. CCI continues to be a regulator which is looked upon by the people of India. But this particular aspect of non-enforcement of Section 42, timely non-enforcement of Section 42, and through the, by engaging good counsel, they should have very good counsel before the High Court, because ultimately the matter goes to the High Court. Because there is no appeal, so the people file writ. And in the High Court, they should have very good counsels to defend their stand. And High Court should be told not to interfere. Because till today, except in one case of Rajasthan surrender, the Supreme Court has said that the High Court should not interfere. There are judgments. So they should know it, and they already know it. So CCI has not, credibility is certainly taken a hit in this particular instance.
So, sir, my last question to you is there any visibility on what happened on the February 21st hearing that Delhi High Court had asked CCI to give to startups
Yeah.
on this
So the
issue?
All India Digital Foundation had gone to High Court. You see, as I said, people have High Court only to go for. And the
This
High
is the
Court,
Delhi High
once
Court.
Delhi High Court. And in Delhi High Court, the CCI Council made a statement that they are already fixed a date for hearing for 21st February for
Hmm.
hearing the application of these people for under Section 42. And so then the High Court said, fine, that we have nothing to do. It dismissed the case. The writ has been dismissed. As I said,
And
High Court will not interfere.
correct.
I've got the order with me right now in front of me. And
Okay.
but one thing I would also add, because your question I did not answer, you said that what will happen ultimately. According to me,
Hmm.
ultimately, like it happened in the US or it happened in the UK, Google will have to come to terms. Google will have to settle this case, because now under the Competition Amendment Act, commitments and settlements are also going to come. They've already been proposed, act has been amended, but they have to be notified by the government. So settlement and commitment are going to happen like it happened in UK or US. This is what my hunch is, that I'm sure Google will see reason, because you can't have two set of laws. One, the RBI, the ultimate regulator, of payment gateways, has mandated that you can't charge more than 5%. How can you charge 11 to 26% and 15% just because you are Google? So I don't think this is a, and Google also knows. I don't know what Google's answers would be, but somebody, as an independent competition law practitioner, I don't think Google has ever got a very strong case.
Got that, sir. So, in essence, now the ball is in whose court? It's in the Supreme Court or
Right now, it is in the Supreme Court and it's also in the NCLAT because the appeal of Google is before the NCLAT. And in
okay.
that appeal, the app developers cannot become a party because there was no informant, only XYZ, as I said.
Mm-hmm.
Though they may try, I can, if they come to me, I can guide them, I can advise them, but it's for their lawyers to think the ways they should be get implemented before the in the appeal also, or they should file a fresh case.
Mm. And the last point is if the regulations come about for settlement and commitment, that can be applied even for existing cases like the app billing one, is it?
See, now the order has been passed in this case. So here there will be no settlement because Competition Commission has already imposed a penalty of 936 crore, as you said. Correct.
Correct.
So
Correct.
there will not be a settlement for this case. But
Mm.
if a new case is filed by app developers,
Mm.
and I'm sure in that case also because Google has not changed its policies dramatically, except the
Mm.
UCB, as I said.
Mm.
I'm sure Google continues to be dominant. So
Mm.
Google definitely will be forced to, show cause will have to be issued. Google at that time, it will be
Mm.
Google's choice if these are notified, either to go for commitments, that is before investigation,
Mm.
or to go for settlement after the investigation by the DG. So it is, as of now, the app developers have to think what they should do. Like, in my personal view, they should
Mm.
actually go for file a fresh case in CCI if they want Google to mandate ways.
So, thank you, sir, for all the perspective. And the big takeaway for me, at least, is that as on date, we are in no position to say whether David will emerge victorious or Goliath will win the battle.
No, I've said David will. So first I've said
Okay.
David will come out. I've said that.
Mm-hmm.
David has
So,
a
you
stronger case. Yeah, I believe
David
in
is a stronger case. Okay. Okay.
that. I've
Mm.
said that.
Point taken, sir. Thank you so much. And thank you for all the perspective.
Thank you very much for giving me this opportunity, Mr. Srivas. Thank you very much.
Thank you.